Question is that this bill be now read a second time. I call the member for Maitland.
Thank you, Mr Temporary Speaker. I rise to speak on the Residential Tenancies Amendment Review Bill of 2018. And as the Shadow Minister for the Prevention of Domestic Violence and Sexual Assault and Acting Shadow Minister for Women, I note that the length of time this bill has taken to reach the House, given one of its primary purposes is to protect those trying to escape domestic violence, particularly women, is shameful. It is now over 800 days since the then Minister for Innovation and Better Regulation announced the proposed changes to the new residential tenancy laws to protect victims of domestic violence. More than 2 years, 2 months and 3 weeks, and yet another example of the tardiness of those opposite when it comes to prioritising domestic violence victims and survivors, and of course with this government, as always, a failure to prioritise women. In the media release of the 5th of July 2016 announcing the proposed changes to residential tenancy laws, the Minister for Prevention of Domestic Violence and Sexual Assault said New South Wales is again leading the way in domestic violence policy by ensuring there is flexibility in residential tenancy law so that victims can swiftly leave their violent partners. I challenge the Minister to explain how leadership takes more than half of a 4-year term of Parliament to bring this bill before the House. Where were they showing leadership? Furthermore, can the Minister explain to the thousands and thousands of children and women and men whose lives have been tainted by domestic violence why they haven't had swift evidence by this government to allow them to leave their violent partners and to have a safe house? This government is all talk and no action. They're focused on the wrong priorities. It shouldn't take 2 years to have brought these changes into effect. This government has not listened to those who speak on behalf of domestic violence victims and survivors. Organisations such as the Women's Legal Service New South Wales and Domestic Violence New South Wales have been advocating for more than a year for statutory declarations from a relevant professional with experience to be allowed by the government. The bill, as proposed, does make a small start, allowing a competent person, defined by to mean a medical practitioner within the meaning of the Health Practitioner Regulation of National Law of New South Wales, to declare a person a victim of domestic violence. But it falls short of what the Women's Legal Service and DV New South Wales have been calling for. As Moo Bolch, CEO of Domestic Violence New South Wales, has pointed out, survivors from at-risk communities may prefer to seek support from people whom they trust in local domestic violence services, community-based organisations, homelessness services or community access workers or disability advocates, rather than a medical practitioner. The Women's Legal Service of New South Wales also points out that research by the Bureau of Crime Statistics and Research and a separate report from the government's own Women New South Wales found that just under half of domestic violence victims report the violence to police. And many choose not to even tell their doctors as a way of ensuring it is not noted on their medical record and potentially put them at risk. This is an issue I've raised in this place before, and something when I worked in the Department of Immigration and Multicultural Affairs, as it was then, before we had border protection, in the revision of the domestic violence provisions around the ability for victims and survivors of DV to apply for spouse visas. When you confine it, you make it very hard for people who have limited English, limited ability to interact with people in authority to actually get the help that they need. Fear of further violence and embarrassment, as well as shame, are some of the key reasons domestic violence is not reported to police or doctors and medical staff. It may also be because the very form of violence that's being perpetrated against these victims and survivors is not medical. It may be that it's a financial kind of abuse. It might be an emotional kind of abuse. It may not have yet escalated to a physical kind of abuse which they might report to their doctors. Expanding the evidence victims of domestic violence can rely on to end their tenancy immediately without penalty must be a priority of the government. I'm disappointed that it hasn't been given greater consideration in this bill. The need to act immediately when domestic violence happens can't be overstated or downplayed, as some of these examples from my own electorate illustrate. Anne, not her real name, had moved 4 times in 6 months to keep safe. She successfully finally gained a tenancy. Her ex-partner broke in through the back door, kept her hostage in the property for 4 days. On top of the psychological injuries, the perpetrator broke her teeth. Sadly, their 4-year-old daughter was also there to witness this incident. Anne didn't want to go back to the property because of the trauma she had experienced there. Fairly understandable, I'd say. Her child was removed by Family and Community Services Child Protection. She was still responsible for the property and needed to keep paying rent even though she didn't want to stay there and she didn't have her child with her. She continued to pay rent until the lease was up, so she didn't get a bad rental history. She now has had finally her child restored to her care and she's been relocated again. A staying home leaving violence referral has been made along with safety upgrades. It shouldn't have had to come to that. In Yvonne's case, again not her real name, she'd moved into a new property but her ex-partner and domestic violence perpetrator found her and forced her to watch him try to hang himself in her lounge room. Her child was removed by Family and Community Services based on reportedly unsubstantiated reports about her. Despite the unsuccessful hanging attempt, the ladder and the rope were left in the property. Understandably, Yvonne can't return to the trauma, however she's still responsible for the tenancy and the process of getting her legal and advocacy advice has now commenced. In both of these cases, the women's Centrelink payments had also been decreased because they no longer had the children in their care. Just more and more structural barriers against women experiencing domestic violence, and this is not helping enough. In a third case, Melinda and her partner were joint tenants. He was bailed back to their property. Melinda's child had to be removed due to his domestic violence. She had to stay in a car because she couldn't get temporary accommodation due to her income being too high and there being no vacancies in the refuge. Melinda's still paying rent at the property so she doesn't get a bad rental. She can't afford to pay for temporary accommodation in addition because of the rent she's got to already pay. And she's in the process of receiving support from the Hunter Tenants Advice and Advocacy Service to get her off the lease. She's currently in the refuge as there are just no other options available to her. These are some of the examples of what's happening in the lives of those affected by domestic violence right now. These are women, if this government had have got its act together 2 years ago, would not have been left in this situation. These are women who rely on rental accommodation to provide sanctuary for themselves and their children. My plea to this government is to have a thorough think through about this bill and the needs of those affected by domestic violence. The risk of losing safety and security at home is very real for survivors of domestic violence and family violence and sexual assault. Women already have too many barriers to leaving homes where they've experienced domestic and family violence. Having to pay more money, double rent, is a very real barrier. And we should be making it as easy as possible for those women and those victims and survivors to leave. And I want to say something about landlords in this context. I know when this first came out there was some talk about the impact on landlords. And I would say to all landlords who have themselves in a situation where one of their tenants is experiencing domestic violence, we all have a responsibility to stop domestic violence wherever it happens. And wherever we have power to stop a perpetrator having power over a victim or survivor of DV, we all need to stand up. It is the right thing to do. But beyond that, it's also important for those people to recognise that if we actually address the issues of domestic violence early, we can get those women to safety, and those landlords, the very small minority who would be harping about the damage to their properties, may find that that is limited by actually giving those women an out instead of leaving them caged in homes that they can no longer afford. And of course, when we don't stop violence in the home early enough, we know that it escalates to very real risk of extreme violence and even death. I also want to talk about this whole issue of the maintenance and the leverage that was spoken about by previous speakers, where landlords have a leverage over their tenants. And I just want to ask for a short extension of time at this point, Speaker.
The question is that the member's time be extended. All to that opinion say aye. Aye. The contrary, no. The ayes have it. The member's time is extended.
Thank you, Mr Temporary Speaker. In my electorate of Maitland, we have a social housing crisis with mould and termites everywhere. And I was very surprised when I put that up on my Facebook page to try and encourage people to report it to me, how many people then came forward with issues around private rentals. And I would urge everyone who is in private rentals or in social housing where maintenance is not maintained to come to your MP if you're not getting any satisfaction in other ways. This should be a call to action for those who have houses. I have walked into houses in the last few months that I am frankly ashamed to be a member of a parliament that has sat and let that happen. it is a disgrace. The mould that has been in some places since the beginning of my term, because the government has just done nothing about the superstorms and the impact on that, and that is now causing a huge increase in termites in my electorate. And I'm sure that there are many people out there in the private rental market who are experiencing the same things. And one of the things that I think can't be ignored in this debate is the absolute humbleness of the people who live in these houses, who have tried to get their landlords, whether it be government or a private landlord, to do the right thing. I've walked into houses that have been an absolute disgrace in terms of maintenance, and the tenants are just wanting the most extreme aspects of maintenance fixed. And I think when we talk about housing and the most fundamental human need to have safe, clean, warm shelter, and we have people who are living in anything but that, who have become so oppressed by the system that has failed them that they accept it, I think it's something as a society we may have to be completely ashamed about. Safe and secure housing is essential to everyone's safety and well-being, and I think that the call to stop the no grounds evictions is part of this. While we have no grounds evictions, we let tenants of public housing, of private housing, we let them in the space where they have no power in the relationship with the landlord, and they will just accept anything to continue to live in a place where they have a roof over their head for them and their children. Everyone's safety and well-being is important, and I fully support the comments of the Shadow Minister, the member for Swansea, on this need to stop no grounds evictions. She was very articulate, and I won't continue on that, but other than to say that tenuous tenure is a downward spiral to homelessness and poverty, and it is a complete and abject failure of this government that there is nothing in this bill to address that. Thank you.
The question is